Good morning. Good morning. I'm Suzanne Scrutton. I'm a partner at the Vorys law firm. Really is an honor to be here today to speak with all of you. We thought it would be helpful today to give you an environmental scan and a regulatory scan of where everything is in the system. I was commenting to some of you earlier that I could not remember a time when there were so many things happening. There's always been a lot of things happening at the county and local level and even at the state level, but there's really been an increase in litigation that impacts this system, as well as federal legislation that impacts this system. So I have a lot of slides today, and I'm going to try to give you just a brief overview of where things are from a regulatory and litigation perspective. Oh, wrong way. Okay, so let's start with an overview of where we are with the Department of Justice and Disability Rights Ohio. I think most of you are familiar with the landmark Supreme Court case decided in 1999 called the Olmstead case, which stood for the proposition that individuals with disabilities have the right to receive services under the ADA in a community integrated setting. Procedurally, how the Department of Justice goes about enforcing that is that they go around the country and, based on various tips that they may receive, including those tips that they may receive from local protection and advocacy organizations, or they might keep their eye on cases that individuals or families file or consumer organizations file on behalf of those individuals regarding enforcement of the ADA, and they conduct their own investigations, and as a result of those investigations, oftentimes they file lawsuits against states, or if there are individuals who file these lawsuits, they may file what's called a friend of the court brief or an amicus brief in order to bolster those organizations' claims under the ADA about community integration for individuals with disabilities. I wanted to point out the U.S. Department of Justice Office of Civil Rights Division has a very helpful web page. If you're interested, I would recommend every so often that you go to this web page and see what they're saying about how they're going to enforce the ADA. It has all the relevant cases that we're going to touch on today, and it gives you the citations and the hyperlinks, so it's real easy to access that. So I wanted to give you that as a resource. The most recent case, and I'm going to touch on some of these cases, is out of Rhode Island, decided last month. It's a statewide settlement agreement regarding ADA violations for over 3,000 individuals with developmental disabilities who were receiving their day services in sheltered workshops or facility-based programs. So that would be some of you in the room. The state agreed to overhaul its sheltered workshops and day programs, and they entered into a statewide 10-year settlement. So pretty monumental, and some of the things that you'll see in here I think have never been in a settlement before that I've seen. It would require that individuals in Rhode Island with they would be required to have typical jobs. That means jobs in the community that other individuals who are not disabled have in the community that pay the minimum wage. So we're not talking about sheltered employment with sub-minimum wage. Supports for integrated non-work activities, including mainstream educational, leisure, volunteer activities in the same community centers, libraries, educational, sports facilities that are available to everyone. Again, so it's not just about work. It's integrated non-work activities as well. And it's in places where everyone else is, not just in facilities or leisure activities where only individuals with disabilities are participating in those activities. I thought this third bullet is very interesting because we're starting to see the Department of Justice focus more on youth. And this is about transition age youth for individual students with DD starting at age 14 that would enable them to leave school and be prepared for jobs in the community at competitive wages. These are kids that would be transitioning out of the education system into the DD system and making sure that they have opportunities as adults that take into account the top two bullets. And as a result of this settlement, there will be sustained funding for 10 years to support the integrated settings. So as you can see, very comprehensive. Traditionally, there's been a lot of cases about deinstitutionalization and access to community services. Here we see really this going a step further. They're looking at day activities, sheltered workshops, facility-based programs, and how they're really seeing that they're promoting access to these typical jobs that pay minimum wage, just like anyone else who's in the job market. Yes.
The last bullet point there, the funding, is that Rhode Island be required to sustain to provide funding, or is the feds helping?
I'm not sure how the funding is. I would have to go back and look at how that's going to work. I assume that it's the state, and then they might be refinancing some of it through Medicaid. But however they're going to provide it, it's a legal requirement on them via this settlement and consent decree. And as you can see, the Department of Justice really sees this as a model for the nation. You can see some of their quotes here. And so I wouldn't be surprised if they would take what the settlement agreement and apply it to other states. Other pending lawsuits, there's a Florida case that's still pending, where the Department of Justice alleges that children with disabilities are unnecessarily segregated in nursing facilities when they could otherwise be served in family homes or community-based settings. Again, it's still pending, but you can see that they're looking at children. And this will dovetail into the discussion that we have when we talk about Disability Rights Ohio as well. There's a relatively recent case out of Oregon. I'm sure many of you may be familiar with it because Director Martin in the last budget often cited it as reason why Employment First and Ohio's Olmstead plan on conversion and downsizing of facilities was so important. Now, Oregon does not have any ICFs, so it's a little bit apples and oranges, but you can see that when it comes to sheltered employment, this was one of the first cases on sheltered employment where the Department of Justice was seeking more community-based programming for their day activities. There's cases out of Tennessee and Georgia. I'm not going to go into great detail over those. You can read those at your leisure out of that web page that I cited earlier. Also, the Department of Justice has filed friend of the court briefs in these states where other individuals and families and consumer groups have filed lawsuits against the state about deinstitutionalization. Again, if I had to summarize what the Olmstead Act, today it started more as a deinstitutionalization and downsizing of state developmental centers, state hospitals, and large ICFs. And now and also the increased access to home and community-based services. But now we're seeing it more focus as well on HCBS services and changes to sheltered employment and facility-based day programming. So Disability Rights Ohio. Disability Rights Ohio, you may be saying, I don't know what that is, because it's a relatively new entity. It's formerly Ohio Legal Rights Service, which was a state agency that was adopted under the protection and advocacy laws that were created under federal law many years ago. And so Ohio chose to have a state entity at the time, and many states chose to have an entity that was a not-for-profit corporation. So what Disability Rights Ohio is the new not-for-profit corporation that was formerly Ohio Legal Rights Service. They are authorized under the Protection and Advocacy federal law to stand in the shoes of individuals with disabilities, and if there are issues that are of concern, including implementation of Olmstead or other violations that they believe are germane to their jurisdiction, they have broad investigatory powers. They're not totally without certain checks and balances, but they are very broad because I just did a recent review of that. They have been visiting ICFs and sheltered workshops around Ohio. They have issued some reports. Those reports on their investigations so far are on their webpage. I'd encourage you to take a look at them because it kind of gives you a glimpse into how they view the world. And the way that they view the world is that they really don't like institutions at all. And in fact, one recent report, the cover page, this facility happened to serve youth, and they believed the quote was, "Youth should never live in an institution." That was the quote. So their bias is against facility-based care and very pro-home and community-based services. There's been a lot of rumors swirling around. Are they going to file litigation? Because they have filed litigation in the past about various issues. We don't know what their intentions are. What we understand so far is that they are about wrapping up their investigations of ICFs and sheltered workshops, and we should know soon what their intentions are, and it wouldn't surprise me if we knew those as early as this summer. So what does this mean for the system? Obviously, we have the Department of Justice. I have no knowledge that they are here looking at anything. If any of you do, please let us know. But we know that Disability Rights Ohio is looking at the system, both on the institutional side as well as sheltered workshops. The state has been smart, I think. They have tried to provide themselves a defense to some challenges. They have codified their Olmstead plan in the state budget. They have the Employment First initiative. They have codified the downsizing of developmental centers and ICFs and the conversion of ICFs to community-based programming. So if there ever were a lawsuit, they would be able to say, hey, we're trying. We know that we have issues, but we have taken proactive measures to try to address these, and nothing's going to happen overnight. Will that be good enough? We'll just have to wait and see. You can see, if you read the 370-some pages of the Home and Community-Based Services Rule that Maureen and I are going to talk about in a few minutes, you'll see, you can look into the mind's eye of the federal government. They have a strong bias. This administration in particular has a very strong bias toward home and community-based services. That's the name of the game. And so we'll talk about that shortly. And of course, Disability Rights Ohio has a strong bias against institutional care as well. So you can see where the trend is going. And of course, we're heading into budget season, and we know that litigation or even threats of litigation can be an effective tool to shape policy. If you remember, even in the last budget, oftentimes Director Martin would say, we can't have the Department of Justice coming in and suing the state of Ohio because we won't have any control over our system and things can be imposed upon us. And that was an effective tool, I think, to try to get all the stakeholders to agree to memorialize the Olmstead plan in the state budget. So again, there may be litigation, there may not, there may be threats of litigation. All those things, though, can impact state policy. Okay, so that's where we are on the litigation front, and I'm going to shift over to some regulatory issues that you should be aware of. The first is Medicaid revalidation. And you're saying, what the heck is that? Medicaid revalidation. Right now, you have a Medicaid provider agreement that lives on in perpetuity, okay? But under the Affordable Care Act, the lawmakers decided that that's not a very good idea. We need to weed out those providers that shouldn't be in the Medicaid program. And so the way we're going to do that is we are going to require states to revalidate Medicaid providers every 5 years. So that is what Medicaid revalidation is. For the first time, the Medicaid agency is going to, based on the risk that they determine your provider type is, they are going to come out or on paper review you to make sure that you should still participate in the program. And providers are screened according to their risk level. And I'm going to talk a little bit about, there's 3 types of risk: limited, moderate, and high. So limited providers who the federal government deems limited in risk, and those would be ICFs and individual waiver service providers, will have really a paper review, okay? And I'll talk a little bit about how this all works, the procedure, in a few minutes, but you're going to have a paper review. The state's going to verify that you meet the applicable Medicaid requirements for your provider type. They're going to verify any licenses, and they're going to do a database check on a pre and post enrollment basis to ensure that you continue to meet the enrollment criteria for your provider type again. So ICFs, it should be a paper review for you, with one exception I'll talk about in a minute. Moderate, and this will affect a lot of you, and it's going to be very different than what you're used to. Moderate would be agency waiver service providers. So almost all of you in the room, you're going to have, in addition to the 3 areas that I talked about a minute ago, the paper review, you're going to have an on-site visit, including a pre- and post-enrollment site visit to determine compliance with Medicaid enrollment requirements. And the way that this is going to work in Ohio is that the Ohio Department of Medicaid has contracted with an entity called Public Consulting Group, PCG, and they're going to come to your facility, and we'll talk a little bit about what they're going to do in a minute. There are also providers that are considered high risk, and those would be new enrollments of agency waiver service providers. I don't think that this is going to impact many of you, because my understanding is that you're a waiver provider, and if you want to add a service, you just add it to your current Medicaid provider agreement, okay? So I don't think it's going to impact you, but if it does, in addition to the paper review and the on-site review, any person involved with your agency with a 5% or greater ownership or control interest is subject to a criminal background check and must submit fingerprints to the Ohio Department of Medicaid. So much different than anything we've dealt with before. Okay, so I'm going to give you some helpful hints on how to deal with Medicaid revalidation. You should be receiving a letter 90 days before your re-enrollment happens. You need to make sure that your name, address, any contact information is correct in the MITS portal, and I've given you the hyperlink to that. Because guess what? They're going to mail it to you, and if it's not the right address or it goes to the wrong person, you could miss out on your time frame, and you can get kicked out of the program. So you don't want that. Also, I'd suggest that you let your staff know that there's this very important document that's going to be coming, and to make sure that it gets to the right person. And I also I should have pointed this out. I know some of you have gone through recertification with the Department of DD. This is a different process, okay? So don't think that you can, if you get this packet, well, I already did that. This is different, okay? This is going to be from the Ohio Department of Medicaid or the Public Consulting Group. Oh, yes.
Do you know anything about the department asking Medicaid for law?
I'm gonna talk about that in a second. I didn't want anyone's head to explode yet about that. Okay.
Folks, this is going to build, so.
Okay, so you need to make sure your contact information is correct, and you're going to pay $532. Now, if you're an ICF, you're going to pay $500, and you have multiple facilities, you're going to pay $532 times however many facilities you have, because you have multiple Medicaid provider agreements. So it's by provider agreement. Now, I don't know if that is true on the waiver side. Again, my understanding is you have one waiver contract for, and sometimes they're site specific and sometimes they're not. So however many sites or Medicaid provider agreements you have, that's how many times 532 you're going to pay.
Yeah, and I believe if you're a TED waiver provider, that is also a separate provider agreement, and it's not the same provider agreement as HCBS waiver provider agreement.
Okay.
So some of you may have 3+.
Very good. Okay, so here's a helpful tip. The ODM website now lists who is going to be revalidated through the end of the year at this hyperlink, because it only previously listed up to June 30th, but now it's through the end of the year. So you can go and see if your provider agency is going to be revalidated this year. And again, it's important to make sure that you have your information correct, because if the documentation is not submitted on a timely basis, you can be terminated from the Medicaid program. Very important. Okay, the Public Consulting Group is the contractor that the Ohio Department of Medicaid has hired to come do these on-site reviews. So those of you who are waiver providers, some of you have already received a visit from PCG. They are doing unannounced visits that will take approximately 60 to 90%. They're going to review your policies and procedures, to make sure background checks are done, perhaps look at some service documentation and other documents to make sure that you're operating in conformance with Medicaid requirements. They can speak to anyone who has knowledge of the business, including but not limited to providers, owners, or office administrator. I would suggest that you inform your staff, especially the front desk person, that when this person from PCG comes in, they're going to give you a business card and maybe a little flyer that says who they are and why they're there, that they be instructed that they need to contact whoever you think is, if it's you or the most appropriate person, because give your cell phone to the front desk person if it's you. Make sure that you have the right person talking to PCG, because you don't necessarily want the wrong person, because they may not be able to access documents and things. So make sure it's the right person, they get to the right person when they arrive. If they determine that certain areas of your business are out of compliance, they will give you the opportunity to do a plan of correction within 30 days. So that'll be very important that you get that in timely if you have any issues. This is also important. I think providers know about this now, but before we even knew that PCG was coming out, they were out there, and some providers said, the CEO wasn't there that day, so they told PCG to go away. Well, you really should not do that. Okay, you really need to try to accommodate them. I think they understood and they went back to certain facilities, but you need to have kind of the chain of command all set in order. And although ICFs are limited risk, if an ICF is providing respite, we're finding that some ICFs are being visited by PCG because they provide a waiver service. So I'm not sure if that's going to get sorted out, but don't be surprised. Just because you're an ICF, you could get a visit from PCG, and I would recommend that you inform your staff of all the things that we just talked about.
So if they show up at the DICF and they're looking at, make sure there are background checks for all your employees and all that good stuff, that's not going to be in your facility, so it's going to be at your office. So make sure that your folks in the homes are cognizant of the fact that they may show up and to contact you immediately.
Okay, so this is the actual checklist that PCG is using when they come out to facilities. Some of these things are not necessarily requirements, like a disaster recovery plan and things, but this is their checklist that they're looking at. Documentation to support Medicaid billing, record retention policies, disaster recovery plan, background checks, and federal exclusion lists, that you're compliant with HIPAA, and that all your certificates and licensure requirements are in place. So I would use that checklist, and I would go back to your agency and make sure that you have all of these things in order and that they're readily available and that you or your backup person knows where everything is. Okay? Okay, any questions on Medicaid revalidation? Oh, and this is the part where I didn't want to make your head explode, so I didn't tell you this initially, but we have heard that the Department of DD may take over this function for the DD system, the on-site visits that PCG is doing. But we don't know for sure if that's the case. So I would just assume at this point that it's PCG who's coming out. Jumping around to other federal requirements that are going to have an impact on providers. Now, I'm going to say this with the caveat that I am a healthcare attorney. I am not a labor lawyer, so if we get too in-depth into this discussion, I'm going to have to direct you somewhere else for a later date. But how many of you use the companionship exemption today? Anyone? Well, okay, I'm going to touch on it, okay? So the companionship exemption is, I just want to make sure we all understand it. That's where the staff lives in the individual's home. It's not foster care, okay? So this is actually homemaker personal care where the staff lives in the individual's home. And if you meet certain requirements, you can utilize the companionship exemption, which means you do not have to pay minimum wage and overtime. I'm going to skip over some of these slides. But what is going to happen is that the Department of Labor has issued regulations to get rid of the companionship exemption. So this is going to have an impact on providers because they're going to have to pay minimum wage and they're going to have to pay overtime for people that they don't pay those two things to today. This is going to likely require those agencies that do utilize this exemption to reconfigure your staffing in order to avoid new overtime liability. And because most of those individuals work over 40 hours a week, they're not going to get as many hours, is my guess, because providers will not want to require them to work over 40 hours a week and have to pay that overtime. So again, another unfunded mandate on providers that utilize the companionship exemption today. They're going to have to somehow make up in their agency budget for these increased wages and overtime. Okay, so we're going to shift now to, I know some of you have heard some of this before, but we're going to talk about the new CMS rule regarding home and community-based services, and I'm going to turn that over to Maureen to get us started.
Thanks, Suzanne. As Gary said, the point of today is really to kind of step back and look at everything going on. So as Suzanne said, we know that some of you have been part of the different presentations recently. We're going to run through that a little bit, hopefully more so, I think, with an eye towards putting it into that sort of full context so that you can be thinking about how this, plus everything else we're talking about, affects your decision making and your governance going forward. So the key elements of the rule that we're going to talk about are some of the kind of core components of it. We're going to talk a little bit about the timelines, a number of the implementation issues, and what does it mean particularly for you as providers. So the final regulations, as you know, came out in March 17th. It impacts every one of our Ohio waivers, both in the DD field as well as in the aging field, our aging and medical waivers. It affects or addresses requirements to all of our home and community-based settings, includes specific components and process and requirements for person-centered planning. And it also speaks about, which Suzanne's going to drill into a little bit more, environments or settings that are presumed not to be home and community based and will be subject to additional oversight and controls. Oops, sorry, I went the wrong way. Okay. So the point of these regulations, or the intent, is to ensure that individuals receive long-term services and supports through home and community-based programs under several different federal authorities. And you can see them referenced here. In Ohio, we utilize the 1915C, which is all of our home and community-based waivers, and so they're all subject to the requirements I'm going to describe. We're focusing obviously today on the DD waivers, but these same apply to passport and to the choices waiver and some of the other waivers in Ohio, and that'll be important in terms of the time frames of what the state will be dealing with. The goal obviously is to address and encourage the quality of services provided in home and community-based services, and I think it's important right at the outset to say that this probably the strongest way that we can say it at this point is that you should look at these regulations as a reflection of what CMS intends to pay for and what they intend to stop paying for in the future. We'll get into that a little bit more, but this is, while some of these things may sound nice or be familiar, we want to be thinking about it in terms of really a shift in the federal payment policies and how that's going to be impacting us as we go forward. Okay? Again, sort of additional general requirements. So these are things that are going to apply across the board as we go through the presentation, or across all the waiver services in Ohio. The general requirements include ensuring individual rights of the consumer, the individual, to privacy, dignity, respect, and freedom from coercion and restraint. The process, as well as some of the individual requirements, are intended to optimize autonomy and independence for the individual in making choices, and including but not limited to daily activities, physical environment, with whom to interact, and etc. And again, process and requirements are aimed at facilitating the choice of the individual in all areas or domains of their life. Now, we're gonna talk now a little bit more about the provider-owned settings, and Suzanne's going to talk with us about that. That will have very significant implications for some of you who currently offer residential services.
Okay, so Maureen just talked about the general requirements, which are kind of like the apple pie of the rule, and now I'm getting into kind of the nitty-gritty, because these are the additional requirements that are going to be required of providers who own or control the setting, okay? And we assume that that means licensed settings, but there's still a question as to could it mean unlicensed settings, and we specifically asked that question of CMS, and they did not answer the question yet. So I'd pay attention if you have unlicensed settings, but we know for sure it's going to apply to licensed settings. The unit or dwelling is a specific physical place that can be owned, rented, or occupied under a legally enforceable agreement. So again, For those of you that don't have a residency agreement, you're going to have something like it. And let me go on and tell you what else is going to need to be in it. The agreement will have to have have contained in it the same responsibilities and protections from eviction that tenants have under landlord-tenant law. If the tenant laws do not apply, the state ensures that the lease, residency agreement, or other written agreement is in place, providing protections to address the eviction process and appeals comparable to those provided under the jurisdiction's landlord-tenant law. This is a little like, this does not compute because the landlord-tenant law doesn't really apply today. And what they're saying is, we're going to make it apply, or we're going to at least give individuals who reside in your homes the protections afforded under the landlord-tenant law. So, we have, as a licensed facility, you've always had to abide by the admission, discharge, and transfer rule, which provides consumers a lot of protections. I mean, it's hard to discharge somebody in Ohio. Doing the analysis, the only thing that you might have to tack on to the end is about an eviction process, which seems like after you've gone through this long process, we may have to modify it in that way. Or what I think we're going to try to do is work with the state to see if they will advocate and we will get CMS approval that Ohio's discharge rule will comply, will suffice in this, under this requirement. Yes.
So this would apply to, so we'd have to add that to ICF rules.
Okay, so let me make sure that, okay, so this is confusing. This rule relates to home and community-based services only. And in fact, we'll talk about this in a minute, but by definition, ICFs do not have to comply with this rule. This rule does not apply to ICFs.
And I mean, there were a lot of discussions that come out of this. Please remember when you're reading the CMS rules, this applies to every state in the country. And, as near and dear to all of this is to our hearts in Ohio and what these regulations look like and, what the implications are here. Every state is in a different place. Every state has different licensure requirements. Every state has programs that look different than every other state. So, when you're sitting back and you're looking at this, in many ways, Ohio is way ahead of other states in some of these areas. In some ways, we're behind other states. So, don't take that narrow of a viewpoint when you look at the impacts of this. The first thing I thought of was, separate and aside from the fact that under current licensure rule, you're not allowed to have a tenant relationship with folks that live in your licensed home, so there's an automatic rule change. The other one is common tenant relationships, and I'm not an attorney, so if I say something wrong, Suzanne will kick me. But if I go out and I get an apartment with you, Jim, and we're roommates, and you decide you're not going to pay your half of the rent, I'm going to be stuck with it because we're going to sign a co-lease. We're not going to sign independent leases for the same domicile. So you're not going to have 4 people living together that have independent leases the way we do sometimes with the nonprofit housing corps today. Those are not common tenant relationships in Ohio and in most states for that matter. So as a practical matter, if you're going to look like the rest of the population when you're renting a place, you're very highly dependent upon your roommate doing the right thing. If not legally, you will get stuck with it. Same thing with utility bills and everything else that goes on today outside of licensed settings. So all of these things are going to surface in the conversation to see how can you actually effectuate and do this. But the requirement is going to be as a home and community-based waiver provider, not as a licensee, because these regulations are around the Medicaid service. And by the way, the Medicaid service does not pay for room and board. In fact, it is expressly prohibited in federal regulations for the waiver to pay for room and board in any waiver. So it's a requirement of the waiver provider on a room and board issue that is not subject to federal funding. Okay, so it makes it kind of dicey.
And just following up, and I'll talk about this more later, these are setting requirements, and yet so much of our system is not setting or site specific. So it makes it, hard to decipher how it's going to be enforced. But we'll talk about that in a few minutes. So on the lease or the residency agreement, we're going to have to work with the state to get some clarity on this. The simplest thing to me would be to advocate that the state of Ohio's admission, discharge, and transfer rule for licensed facilities is very consumer friendly and provides protections to individuals, and that should suffice. And maybe you'd have to have a residency agreement that would reference that section of the law and spell it out for someone that they could understand it. We may have to tack on some of the landlord-tenant requirements on the end of that process. That would be kind of the worst-case scenario, I think. Okay, let's talk a little bit more about some of these additional requirements. Oops. Okay. The individual has privacy in their unit, including lockable doors, choice of roommates if sharing, and freedom to furnish and decorate the unit. Let's break this apart because there's a lot here. The individual has privacy in their unit. The federal government was pretty clear in the comments to this rule. They don't mean that everybody has to have a private room. Okay, so that's a good thing. But what they mean is that the state has to have options for people that include private rooms in the system, including lockable doors. That's a lockable door from the inside. Okay, and that, we know that's going to, for some folks, that's going to present a health and safety issue. There are ways to modify these requirements through the person-centered plan, and we'll talk about that in a few minutes, okay? Choice of roommates and freedom to furnish and decorate the unit. The individual controls his or her own schedule and activities, including access to food at any time. Okay, so there's going to be practical issues associated with this one for sure, okay? But again, let's say the access to food at any time. If there's a health and safety reason why someone should not have access to food at any time, it needs to be put into the person-centered plan, because that is the only way you're going to modify these requirements is in the plan. So the plan will take on more importance, as if it weren't more as important as it is today. It's going to take on even more importance to ensure that it is accurate. Okay, individuals can have access to visitors of their choosing at any time. Okay, so here we've got complex situations. You've got individuals with differing service needs and different levels of mild, moderate disabilities. Might be okay for somebody to have access to visitors at any time, one person in the home, but not because of another person. You might not want that visitor in the home. Again, the only way to modify that is to put it in the plan. And a choice.
And I know several of you out there have run into this very issue today, and it's been very, very, very difficult to effectuate that language in plans. You have an individual that makes very poor choices about who they might bring into the setting that could adversely affect other folks that live there in a vulnerable way, and have not had a lot of support through the ISP process and trying to effectuate a reasonable decision by the team. So when Suzanne says these become critical ISP issues, they really are, because if not, you're faced with the CMS rule saying that's the way it is, folks.
Individuals have a choice of a provider in a provider-owned setting. And I was kind of worried about this initially, that it could mean you could have, in a licensed home, you could have somebody else coming in. But I think CMS has clarified that in the comments, that when you're picking the facility, you're really picking the provider in the facility. So I think we're okay there. Let's talk about the person-centered plan. Okay, again, the plan is going to take on an importance that it doesn't have today, because it's the only way that you're going to be able to get an exemption from the requirements that I just read, that we just talked about. Modifications of the additional requirements must be addressed in the person-centered plan and be supported by a specific assessed need. There's a question about who does the assessment. Is it, we're going to have disputes about, is it what the provider thinks or what the county board thinks? We just know that we're going to have that. We're going to need to get clarity about that issue. Needs to be justified in the person-centered plan and documented in the plan. The plan is supposed to focus on outcomes and, where possible, is led by the individual receiving the services and supports, including the individual's representative. So again, there's a lot of things about this rule that are good, I think, for providers. That it's very family and individual focused, whereas in the past it's not always been that way. It must reflect the services and supports that are important to the individual to meet their needs, and what's important to the individual with regard to preferences for delivery of services and supports. As far as the process goes, the team meeting will include people chosen by the individual. The plan should provide necessary information and support to ensure that the individual directs the process to the maximum extent possible, that the team meeting would be timely and occurs at times and locations of convenience to the individual. That's not always the case today, so that's a good thing. Reflects the cultural considerations of the individual, includes strategies for resolving conflict or disagreement with the process. That's very important because we don't have that today. And I would say that we need to have some type of state policy regarding how disputes are going to get resolved, because again, you are going to be bound to comply with those additional requirements if we cannot modify them in the plan. And there are going to be disputes, I'm sure, between how you see it, how a family sees it, and how a county board sees it in the plan. Okay, providers of HCBS for the individual or those who have an interest in or are employed by the HCBS provider for that individual cannot provide case management or develop the person-centered plan. Now there's an exception, I'll read that in a minute, but what that means is that if you're an HCBS provider, you can't be the case manager. Well, certain county boards are providers of HCBS services and perform the case management function. So we're going to have to get some clarity on that and what where the state of Ohio and the federal government come out on that conflict of interest. And I'm going to read you the same section with the caveat. I'll read you the caveat. In these cases, providers of HCBS for the individual or those who have an interest in or employed by the HCBS provider for the individual must not provide case management or develop the person-centered plan, except when the state demonstrates that the only willing and qualified entity to provide case management and or develop person-centered plans in the geographic area also provides HCBS. In these cases, the state must devise conflict of interest protection, including separation of entity and provider functions within provider entities, which must be approved by CMS. Individuals must be provided a clear and accessible alternative dispute resolution process. So we'll have to see how the state of Ohio will deal with that. They're going to have to deal with it because I think that the way that the state operates is contrary to that section of law.
A good number of years ago, Ohio created what was called the firewalls document to address CMS concerns many years ago on this subject matter. But in my opinion, this rule tends to be much more clear on this subject matter than what was in place even back then when CMS had a concern about how Ohio was doing case management.
Okay, just carrying on here, offers choices to the individual regarding services and supports, includes methods to request updates to the plan, records alternative home community-based settings that were considered by the individual. Now we get into the microscopic print. I'll let you read many of these at your leisure, but again, it's intended to address the person, to document their needs, wants, wishes, reflects their clinical and support needs, their goals and their desired outcomes. The one thing I would point out is that it requires informed consent of the individual in writing and signed by all individuals and providers responsible for implementation. Again, that will bring up the whole guardianship issue and whether certain individuals can give informed consent without someone else assisting them. So just wanted to point that out.
Suzanne, I might
Yes.
also just point out the provision that says that it includes, it prevents unnecessary or inappropriate services and support. So obviously the intent of that was to not overserve folks or provide too much, structure or, services if they don't need that or don't want that. We may end up with some discussions in Ohio about, or debates maybe about, that as a vehicle to withdraw support from someone, and is that really what they need or want?
Okay, so just to summarize, it's likely that residential providers are going to have to revise their policies on the following areas, the areas that we talked about. All right, let me just make sure, we talked about a lot of things. I just want to make sure that we understand that these requirements only apply to home and community-based service providers. And those additional requirements that we just went through only apply to those that are provider-owned or controlled settings. There are entities, there are settings that are not community-based, and so these rules do not apply to them. I just want to make that clear, and we talked a little bit about that earlier. Nursing facilities, institutions for mental disease, which are called IMDs, intermediate care facilities, and hospitals. Okay, so you have the one continuum. You're an institution, essentially, and you're HCBS. And we're talking about the HCBS entities. But there are going to be some settings that might be in between. And what do we do about that? And the federal rule says that we're going to presume that certain settings are not home and community-based settings until you show me otherwise. That would be a waiver program on the grounds of an ICF, for instance, or respite in an ICF, where there's kind of the hybrid, okay? They're going to be subjected to what's called heightened scrutiny. I'm going to talk about that. Any locations that have the qualities of an institutional setting and do not meet the threshold for Medicaid HCBS include those in a publicly or privately owned facility that provides inpatient treatment, like a hospital, okay? On the grounds of or immediately adjacent to a public institution. And that means a public institution is a developmental center or a state hospital. It's not an ICF. But don't think that you're going to get out of it, because there's this third prong. Have the effect of isolating individuals receiving Medicaid HCBS services from the broader community of individuals not receiving federal Medicaid HCBS. We know that there are all sorts of federal streams of money that were set up for people with disabilities specifically for that purpose, and of course people with disabilities are going to live in that facility. So but they're going to be presumed to be not HCBS under these rules. And let's talk about how providers and all stakeholders are going to have to deal with these issues. So settings that are presumed not to be HCBS are going to be subjected to what's called heightened scrutiny. And the state will have to submit evidence, which should include public input from all of you, demonstrating that the setting does have the qualities of a home and community-based setting and not the qualities of an institution. And then the Secretary of HHS will find, based on this heightened scrutiny review, that the setting meets the requirements or not. And the way that this will be done is through the transition plan and the various state plan amendments and waiver renewals that the state of Ohio will be seeking from the federal government. Okay, let me talk about this for just briefly. So it says the state has to submit the evidence. So we have to somehow convince the state that they should submit this evidence. We have to, be advocates for our own situations. And I know there's going to be many situations, there's going to be different variations on a theme of disability-specific housing. And we're going to have to figure out a way to convince the state that these are worthy and meet and somehow comply with the HCBS requirements, and convince CMS that that's the case and get their blessing. Well, let's talk about some of the implementation issues. We've touched on this. Again, we have a lot of non-licensed settings, supported living, and they're not site-specific, and yet these are setting requirements. So I assume the Department of DD will somehow have some checklist that they're going to look at, although they don't come out to all of your facilities, to ensure compliance. They don't come out to all of your locations now because it's not a site-specific certification. So that's the quandary that we have with implementation of this and compliance, because the state of Ohio just simply does not come out to every single location to assess whether you're in compliance. Okay, so again, we have a lot of settings that may or may not be in compliance with these requirements, and how are decisions going to be made about whether this qualifies as an HCBS setting? Will there be an appeal process, especially with regard to the departmental discretion? Let's say that they tell someone that your facility is not compliant with the HCBS requirements. What recourse will you have? It's not clear today. We're going to have to address that. Will your Medicaid payments be denied? Remember, this is all about Medicaid. The federal government is saying this is what we're going to pay for under Medicaid. Will your Medicaid payments be denied during your appeal, assuming you get an appeal? Are there other sanctions that might be imposed upon you? These all still remain to be seen.